Can I inherit property without probating a will? Losing a loved one is hard, and thinking about court processes can feel overwhelming. Some Texans believe that if a loved one left a clear will, their wishes can simply be carried out. But in Texas law, a will has no legal authority until a probate court admits it and appoints an executor. If you skip this step, titled assets such as real estate, vehicles, bank accounts, and investment accounts remain legally frozen. Failing to probate within 4 years of the decedent's death can mean beneficiaries lose the right to inherit and the estate reverts to intestacy laws. These consequences often lead families to hire a lawyer to guide them through probate or find alternatives. Texas law requires a will to be probated within 4 years, but there is a narrow exception. If the applicant can show they were not in default for missing the deadline, for example, the will was unknown, or erroneous legal advice prevented timely filing, a court may still accept it. This exception is fact-specific and requires the applicant to exercise reasonable diligence. Without this showing, the will becomes legally useless, meaning heirs might have to rely on intestacy law that follows a fixed distribution formula. If you are asking whether you can inherit property without probating a will, the direct answer is generally no. A will that has not been admitted to probate cannot transfer ownership. However, some property does not require probate because of how it is titled or because a non-probate device was used. Assets with beneficiary designations such as life insurance policies, retirement accounts, and bank accounts payable on death transfer directly to the named beneficiary. Property held in joint tenancy with a right of survivorship passes to the co-owner, but in Texas the right must be expressly stated. Assets held in irrevocable living trust are conveyed through transfer on death or Lady Bird deeds also bypass probate. Even with these devices, an executor or attorney may still need to use probate assets to pay debts before distributing non-probate assets. For property named in a will, probate remains the primary way to clear title. Probate assets are those owned solely in the decedent's name without a beneficiary designation. These include homes, vehicles, and accounts titled individually. To change ownership, an executor must open a court-supervised estate. Non-probate assets transfer automatically and include life insurance, retirement accounts, property held in joint tenancy with a right of survivorship, assets in living trusts, and real property conveyed by transfer on death or Lady Bird deeds. Texas law makes this distinction critical because only probate assets must go through court. When a valid will exists but estate administration is unnecessary, Texas offers a streamlined probate called a muniment of title. This process allows a court to recognize the will as authority to transfer property without appointing an executor. The court issues an order admitting the will as a muniment of title, and this order, once recorded, clears title to real estate. To qualify, the estate must have a properly executed will, no unsecured debts, and no outstanding Medicaid estate recovery claim. If the estate includes bank accounts, investment accounts, or property outside Texas, a full probate is still necessary. For heirs of modest estates where no will exists, the small estate affidavit is a useful shortcut. It allows heirs to collect property without appointing an executor, as long as the estate's value, excluding the homestead and exempt property, is $75,000 or less, the estate's assets exceed its liabilities, and at least 30 days have passed since the decedent's death. All heirs and 2 disinterested witnesses must sign the affidavit, and a judge must approve it. Even with approval, some financial institutions may still require formal probate documents. The affidavit of heirship is another option when no will exists and the primary concern is clarifying ownership of real property. This sworn statement, signed by a family member and disinterested witnesses, establishes who the legal heirs are. It does not legally transfer title but creates a presumption of heirship that may make it easier to sell or refinance property. Because it lacks a judge's order, title companies may be reluctant to rely on it. Probate can be avoided entirely with proactive planning. Creating a revocable living trust transfers ownership of assets to a trustee during life. Upon death, a successor trustee distributes assets according to the trust's instructions without court involvement. A transfer on death deed lets an owner name a beneficiary for real estate and takes effect upon death, allowing the owner to revoke it at any time. A ladybird deed functions similarly but gives the owner greater flexibility to sell or mortgage the property and can be executed through a power of attorney. These tools provide privacy and control while minimizing costs and delays. A knowledgeable attorney can explain which strategies fit your situation. At the law office of Whitney L. Thompson, we understand that navigating probate and inheritance issues can be stressful. Our law firm helps clients identify probate and non-probate assets, use shortcuts like muniment of title or small estate affidavits, and implement trusts or deeds to avoid court. Call our lawyer team at 281-214-0173 or visit us at 4201 Farm to Market 1960 Road W, Suite 360, Box number 116B, Houston, Texas 77068. We're here to provide guidance and peace of mind.